The Supreme Court's decision on Purdue Pharma bankruptcy deal. The recent announcement by the Supreme Court regarding the pause on a bankruptcy deal for Purdue Pharma has sent ripples through the legal and healthcare communities. This landmark decision has far-reaching implications for the opioid epidemic, mass injury cases, and the use of bankruptcy courts as a resolution tool. In this article, we delve into the details of the court's decision, its broader implications, potential viewpoints, and the critical aspects surrounding the case. Unpacking the Supreme Court's involvement. The Supreme Court's decision to intervene in a bankruptcy court dispute, particularly one centered on a mass injury case like the Purdue Pharma settlement, is uncommon. Typically, parties are motivated to settle rather than endure the lengthy and costly process of escalating a case to the highest court in the land. However, the involvement of the U.S. Trustee Program, an oversight division within the Justice Department, added a unique dimension to the case and raised questions about the legitimacy of the settlement. A glimpse into the broader implications. The Purdue Pharma case isn't isolated. Its outcome could establish a precedent for other mass injury cases navigating the bankruptcy court system. The central issue revolves around the concept of non-consensual third-party releases, a mechanism enabling entities like the Sackler family to evade civil lawsuits. If the Supreme Court allows such releases, it could set the stage for more businesses and plaintiffs to employ bankruptcy courts as a means of resolving complex cases involving mass injuries. On the contrary, a ruling against non-consensual third-party releases could unravel years of negotiation and compromise that culminated in the Purdue Pharma bankruptcy settlement deal. This could cast doubt over other similar deals, including cases like the Revlon bankruptcy, sending shockwaves through the legal landscape. Navigating the Supreme Court's stance. Predicting how the Supreme Court will interpret and decide on the case proves challenging. While the conservative majority of the court tends to align with business interests, nuances emerge within this context. Several conservative justices have expressed reservations about aggressive litigation strategies, revealing potential complexities in their perspectives. Furthermore, the court's skepticism towards lower courts acting without explicit congressional approval introduces an element of uncertainty into the equation. Notably, the outcome might defy traditional political or ideological divisions, potentially leading to a split vote among the liberal justices. This procedural complexity further underscores the intricacies of the case. The clash of money and principle. A pivotal point of contention lies between financial considerations and ethical principles. Thousands of plaintiffs, encompassing states, local governments, tribes, and individuals, have waited for settlement funds as litigation costs mount. While the Sacklers incrementally improved their offers, the objection from the U.S. Trustee Program hinged on the potential disparity between the benefits and costs the family would bear. The Sacklers' proposed deal presented an opportunity for them to enjoy bankruptcy's protective benefits without fully disclosing their financial standing. This posed a challenge to the constitutional due process rights of those seeking to hold them accountable in civil court. The U.S. Trustee Program emerged as a lone defender of these principles within the Purdue litigation. The offer on the table. The Purdue Pharma bankruptcy deal outlines a multifaceted approach to addressing the opioid crisis. The company itself would cease to exist, with its assets transitioning to a new entity called Noah Pharma. Under this plan, Purdue would contribute $1.2 billion immediately after emerging from bankruptcy, accompanied by additional payments over the years. The Sackler family, meanwhile, would commit up to $6 billion over 18 years. Importantly, Native American tribes are eligible for payouts from a trust totaling around $161 million. States and local governments have devised distribution formulas, all guided by a commitment to combat the opioid crisis through addiction treatment and prevention initiatives. A ray of hope for individuals. While the collective impact is significant, the Purdue plan doesn't overlook the individual victims of the opioid epidemic. A dedicated trust, with funds ranging from $700 million to $750 million, aims to support victims and families affected by OxyContin addiction. This includes children who experienced withdrawal symptoms due to prenatal drug exposure. Although the individual payouts might appear modest, the acknowledgement of individual suffering marks a departure from conventional settlements. Conclusion and the road ahead. The Supreme Court's decision to pause the Purdue Pharma bankruptcy deal reverberates beyond its immediate scope. It brings to light critical questions about the use of bankruptcy courts in mass injury cases, the balance between financial expediency and ethical accountability, and the potential for precedent-setting outcomes. As the legal proceedings unfold, stakeholders, legal experts, and the public await the court's verdict with bated breath. Now this section is for some important answers for you. Why did the Supreme Court intervene in the Purdue Pharma bankruptcy deal? The court's involvement is unusual and stems from the U.S. Trustee Program's petition, highlighting concerns about the legitimacy of the settlement and its potential consequences. How might the Supreme Court's decision impact other mass injury cases? If the court approves non-consensual third-party releases, it could establish a framework for resolving similar cases through bankruptcy courts. Conversely, a rejection could cast uncertainty over existing deals. What factors influence the Supreme Court's stance on the case? The court's conservative majority's pro-business stance is balanced by reservations about aggressive litigation. The outcome could defy traditional ideological divisions. Why is the Justice Department the primary objector to the Purdue plan? The Justice Department's objection underscores a clash between the financial interests of the Sackler family and the principles of due process for those seeking accountability. How does the Purdue bankruptcy deal address individual victims? The plan includes a dedicated trust to provide compensation for individual victims and families affected by OxyContin addiction, signaling a departure from conventional settlements.